So if you watched my video yesterday on Kelsey Fitzsimmons, you know that her application to the higher court for appeal was denied, but she is back in court today on a habeas petition filed by her attorney with the new information and a new application to have her released by the holidays so she could spend time with her family. So I have the document and the habeas motion that was filed by her attorney. So let's take a look at it and let's see what we're going to do. So if you don't know who I am, my name is Stephanie. I'm a criminal defense attorney, specifically a public defender. I have long nails. If you hate them, move on. Let's take a look at the document. So essentially, this is it's a habeas corpus petition due to a change in circumstances, and it's basically her attorneys saying that they have new information for the court about the scram situation. Okay, because if you remember correctly, back in September, the judge put her back in custody for violating the scram conditions because she could not blow into the machine because she was still recovering from being shot. So down here it says the court previously found conditions of release existed that could reasonably assure the safety of the community, and that included a scram alcohol monitoring. She was remanded because she was physically unable to comply with the scram conditions. Significant time has passed since her remand to custody. During the time, her gunshot-related injuries, including rib fractures and lung trauma, have healed sufficiently to allow her to breathe into the alcohol testing device. She's been tested at the DOC facility and is now able to exhale at the average force for an individual with her demographics. They are going to be submitting a medical report from Western Massachusetts Women's Correctional Facility. She's physically now able to comply with the scram breath testing without the physical incapacity or resultant injury. This constitutes a material change in circumstances, which is what you need to make the habeas petition. There has to be a significant change in circumstances or a material change in circumstances. And directly revolves around the sole condition the court previously identified as a preventing continued release. This constitutes reopening when a change in circumstances has a material bearing on whether the conditions of release can reasonably assure the safety of the community. So they're asking essentially for this to happen. Now, whether you like this case or you don't like the case, we should never want somebody to be held for absolutely no reason. So that hearing is going to be today at 2. I think it's going to be publicized, but I'm not sure. I would definitely check Melanie Little's page around 2 o'clock because if it is going to be televised, she will definitely be televising it. So definitely check back for that and look for an update around that time for me to let you know whether or not she was released, and I hope that she is. So that's that, and here we go.